Awesome. Welcome everybody to our May 27th event, Contract Rights and Wrongs. We're so excited to have you here on behalf of the Comic Legal Defense Fund staff and all of our membership. We have an amazing lineup of folks in the field here to talk all different angles about the importance of contracts and juicy nuggets for you to think about. Hopefully some things you can walk away that you feel are applicable. I want to briefly introduce the team here. I'm Karen Evans. I'm Education Coordinator, and I'd like to introduce Georgia Nelson.
Hey guys, I'm George Nelson. I'm the Director of Operations, and this is Sophie. And then Jordan.
Hi, I'm Jordan Smith, and I am the digital editor for CBLDF, and I'll pass it off to Jeff.
And I am Jeff Trexler, the interim director, and we're delighted to welcome you all here. We have an amazing panel with representing a wide range of interests in the comics community. Contracts have been a question that we've been getting questions about contracts literally since before I came on board. When it was announced that I was going to be joining, I got a flood of requests, and it was contracts, something we really want to be hearing more about. And it's an issue that's become even more heated over the past few months. There have been questions about what happens when a publisher sells your contract or a publisher gets acquired? What happens when there's new technology? Merchandising, suppose you cut a fashion deal, suppose you cut a TV deal, suppose you go into syndication, you have a newspaper comic or a web comic. There are all of these questions that have been arising. So what we thought we would do would be to assemble a panel of people from all of these different backgrounds to talk about their experiences, what works well, what things to avoid. And to start, I'd like to throw it over to Skinner, amazing artist who has a lot of experience across the board here with these issues. And I'm wondering, what's your thoughts on what works with contracts? What doesn't work with contracts? What's been your experience?
Well, first of all, I would say that if you're getting to the point where as an artist that you're doing contracts, that you should at least have contact with a lawyer or an attorney or somebody who understands the verbiage of what's in the contracts and stuff, because sometimes it's gonna sometimes it gets to the point where like you just can't handle it. Like you have to have somebody else negotiate it who's a professional, and it's worth paying that time, for that. But I think that like a lot of artists just in general and the public in general are just not privy to the levels of what somebody's buying. And I don't think overall that even the people that are giving you the contract really understand all the time either. Or say, even if it's like not a contract per se, but somebody that you're signing up to do a certain amount of work, and then they but it's not clear what the usage is, what the band can do with the art or the company or the whatever. And so there's like levels. There's like, are you just selling the rights to license this for a certain amount of time? Are you selling the copyright to the artwork? What does that mean? What does that mean for you? How much money is that going to be? And like, I think that it can be really daunting for a creative person who isn't necessarily adept at business. And because here's the thing is like, you got a sensitive little weird freaky art person who's like, I like to draw and express myself. And then they're running up against somebody whose job it is to exploit you to the fullest, And so you have to kind of, have to think like in this way that is not natural for you. And to me, I've gotten better at it because I kind of hate the idea of artists being exploited to the point where I'm like unreasonable, and so I just say, well, I just want, they're like, hey, how about this amount of money? And I go, how about like 10 times that, and then they're like, what? And I'm like, yeah, just stop emailing me unless you're gonna pay. And then they just kind of want to pay. It's like, it's really psychological warfare in a lot of ways that I don't think people who don't have a foot in this arena kind of understand. Like actually saying no confuses people. If you're an artist, you're just like, nah, I'm good. And then all of a sudden they're like, wait, what? Oh, okay, we'll adapt to you, however, and so my experience is also like trying to understand that you want to ascertain what the budget is, or what they're willing to tell you what the budget is. And you don't just tell somebody, if they go, hey, what are your rates? And you go, oh, well, $500 for a shirt design, whatever. Now, all of a sudden the budget that they had allotted in their mind, which was, and this happened to me early on in my career. I was approached by a big skateboard company, and they had like 50 grand allotted to this thing. And I was like, how about $7,000 for, the design? And so you realize that like you have no bargaining power as an artist, as the person who creates the thing that validates what their business is based on, right? So you gotta understand like what they have available, and then you can negotiate from there. Because if you just say you don't know, unless you have like a set limit, if you're like a super famous artist and you go, well, look, these are my rates, and they're just like completely outside of what a normal bargaining dynamic would be based on. And it's just like, this is what it is. You want to license this image from me? It's like 75K or whatever, So yeah, it's, I mean, I don't even know if what I'm saying makes sense to people, because it's very based on my own abstract experiences. And I don't know, it's also, there's the person you deal with, and then there's the person that person deals with. And they're like standing by the safe and they have a gun and they're like, no, you can't have any more money, and like, but I'm just like, all right, cool. Well, I'm not going to do this for that amount of money. That's ridiculous. Mm-hmm. And, you just have to like kind of pull their card sometimes. And I don't know. I honestly, overall, I would say if you're an artist, you have to understand that none of these companies, none of these institutions would have anything worthwhile to sell or whatever if they don't have the art. Okay? If they don't have the art, there's no video game, there's no skateboard, there's no album cover, so the artist is very psychologically programmed to feel that they're low on the totem pole. But in the material reality, they're the highest on the totem pole. An artist can be a business person, but a business person cannot be an artist. You know what I'm saying? It's like, it's, and so that's the way I approach it. I'm a very like, I don't know, like union-minded person, where I'm like, nope. And so I am always trying to bring up artists with me and make them understand the value of what they have. Because if you do have an internal sense of value, then you're gonna be able to navigate contracts better based on an innate sense of your connection to your value. And so like, you don't even have to be like a, I don't know, like a contract shark person. You could just be like, no, this ain't fair. This doesn't feel right to me. Because what are they going to do? Go to somebody else and then be like, get less or what? It's just like, I don't know. I kind of just do my own thing now. I don't even take jobs anymore. I'm just, it's like, I just go like, cause I just like, give me all your money. They're like, no, I'm like, all right, well, I'm not going to do it, man. So I don't know. I'm an unreasonable person now, but I don't know. I don't know. You just got to find your own lane, and you have to like really cultivate your sense of self-worth and how that interacts with like the world at large. Because if you don't take a stand, the world wants to, pimp people out. This is capitalism. It wants to exploit us to the fullest. And artists need to be hard you know, like hardened, kind of tough about this stuff. So I don't know. I'm just kind of ranting.
No.
Oh, I have a question for you, Skinner, though, because I think this is important and it'll be helpful to artists. So what if you are a newer artist and you're not necessarily established? Like, what is that intersection between self-worth and market value for your art? Like, how do you establish that? Like, what is your advice to the newer artist?
Right. Okay. This is like really hard, but it's sort of, there is a learning curve for sure. And I think that when you're starting out, I think that there's well, okay, this is what I would like to say. You know, in like unions or work in like work environments, you start out and you get paid a certain amount. You're like, okay, I'm starting out, but you're like protected and appreciated if you're like in a union. But then over time, you move up and up and up, and then you can kind of determine your own like level of like what you're worth based on your craft, based on your experience, whatever. There's a lot of artists where they start out and kind of misinformed because of the illusion of the internet, making people who have not necessarily paid their dues or have that much dirt under their fingernails as far as experience and time, like they think they're ready to go. Give me the money for the band shirts and I want this premium price. And it's like, but you just started out and you have a misunderstanding about your experience and your worth based on how many people like you on Instagram or something. You know, it's like, there's not a very, formal understanding of where you're at based on you know, how much you've committed to what you're doing as an artist, as a creative, as a musician or whatever. And so I think that like there's charging prices that feel fair, and then understanding that there's going to be times where, you know, it doesn't really work out, but that those are learning experiences that you're supposed to have. But the thing is that if collectively people understood that art and creativity is what all this stuff is run on and validates all this stuff, people would have less of a struggle, I think, at the beginning of their careers, because it would be valued. It'd be like, oh, good, you're doing this thing. Cool. Yeah, I want to encourage you to keep going, because if I encourage you to keep going, then you're going to contribute to the richness of life for everybody or whatever.
I want to jump in.
An answer at all.
No, it is an answer, because we've hit a number of questions about understanding your worth, understanding the different negotiating positions, the importance of the artist as a business person. And I want to throw, we have other, I want to get everybody in on the conversation. We have so many different backgrounds here. Yeah. With Lillian having been attorney with DC, and Thomas has extensive film experience, and Stu has worked with a number across the industry, and particularly with cartoonists, and Robyn with tremendous tech experience. And I'm wondering if, Georgia, could you throw up a quick poll? I'm just curious, for those of you in the audience, and I'm so sorry we can't see you in the webinar, I'd be interested in seeing, just taking a second, what sort of interests you have. So maybe over the next 15 seconds or so, if you could take a quick look at that list and check as many of these aspects of contracts that you're interested in. And just so we get a sense of who's out there and what you're thinking about. And then we're going to jump. We've heard from the artist perspective, and Lillian has worked with both artists and one of the biggest companies in the business. So I'd be interested in going to Lillian's perspective next.
Okay, on one of these topics, or should we wait to see what?
Just go with whatever you find is of interest to you. This is.
Well, first of all, clearly Skinner is a very skilled negotiator. I would not want to be on the other side. And you also, Skinner, you said something that was very interesting. You talked about the fact that we don't have a union in comics. And I think that that's a mistake. And I wish it would be a lot easier, I think, for both sides if we did have a guild or a union. And when I was at DC Comics, the company was run by creatives, very creator friendly people who initiated royalties and all these, benefits that had never existed before for creators. And it was not terribly appreciated at the time. And we always thought that we would be better off, this is management saying, if talent had a union. And there were standards across the board. It would have made our lives a lot easier. Okay, so there's, media rights seems to be a winner. Okay. Often publishers will want to get all rights in a deal, and not pay for them necessarily separately, but pay an advance or a page rate for a book and then get all of the ancillary rights with it. And unless they're attached to a studio and have some kind of a first look deal with the studio, it's really not a good idea to give away all those rights at the outset. You might give a right of first negotiation or an option for a period of time. There are a lot of ways to handle media rights. I mean, some creators insist on keeping them. In that case, publishers often ask for a passive participation if the media rights are sold to another party, which is fair because the publisher is investing substantial human and financial resources to develop the property and market it and make a market for it, to make it a success so that studios would be interested. And if they don't have all the rights, they usually will get a passive participation. And what else? Ask me a question.
Oh, yeah, sure. One of the things that was raised in the discussion with Skinner, and I was really glad that Robyn had asked this question, was comparative value. I know it's a question that I've actually been getting since coming on board at the CBLDF. It's that people feel like they're negotiating into the void. It's like they don't know what other creators are being paid, and they don't know if they're being offered something really low or being offered something really high. If you're going into a contract, how do you avoid making the mistake of underselling yourself, and how do you avoid making the mistake of, say, overpricing yourself when you're going in and maybe losing a deal because you had too much of a sense of what you were worth?
Well, go ahead.
Go ahead.
Well, I mean, Skinner really stole my best idea for this, which is that there's two parts to a contract. There's the process of getting to the contract, and then there's the contract. And he really highlighted the fact that the process is important, and that's really overlooked in most negotiations, especially by artists who really just want to jump to the end. Oh, wow, I wish we didn't have to deal with all of this. I wish I just had this contract done. It's really frustrating. But the fact of the matter is, if you ask for something with a smile on your face, and it's not crazy, I mean, if you ask for more money, that's not crazy, and they say no, that's ordinary business. If they say no and they give you any attitude, that's a big, giant red flag. Yeah. And that was probably the first real lesson that I learned in negotiating on behalf of artists, which is these people are just business people who come in to work. They have a mortgage to pay. They don't really care.
Yeah.
And so at the end of the day, if you're getting static and anger back for something, even if it's outside of the market rate ask, they're just going to say no and come back to you with what they can do. And if you get a really skilled negotiator, they may lowball you, but they're not going to come back with, some sort of death squad. I mean, they're not coming after you. They're just going to say no. And the couple of times that people have said no to my clients and given them attitude, I mean, that has been a warning that you don't want to be in a long-term relationship with these people because they're just not that into you. And so process. And so don't be afraid of the process, embrace the process. No, especially if you're doing a piecemeal work, that's one thing. But if you're signing a deal like my client signed, which is a 10-year deal, a 15-year deal, the negotiating process is the only time where you're actually going to get real hardcore feedback as to just how dedicated they are to you. I mean, I have had people who've walked away from TV deals that they would have accepted if they smelled that the other side was excited, but they smelled that the other side just wasn't that interested and they were going to sit on a shelf. So again, embrace the process. And then as to the ultimate contract itself, yeah, I mean, of course that's important. And I think some of the other attorneys will weigh in on some of the specific deal terms. But the biggest mistake that people can get into in a contract is just being so dedicated to it being short that they don't think toward the future. Like this week, I'm actually working on my very first NFT deal. And my client is a syndicated cartoonist. And he got an offer from somebody who's out there trying to build this business for himself. And the first thing I did is I went back and I looked at the contract. I'm like, oh, wow, is this original art or is this subsidiary licensing? And I looked at the deal that I, wrote up back in, the early 2000s, where I didn't ignore the issue of original art. I said, I specifically reserved original art for my client. And so I'm going to take the position that this is original art and hope that the syndicate doesn't fight back and say that this is subsidiary, because I think I'm right. But, even though I was careful, I didn't see people being willing to pay for something that they didn't want to pay for. So, embrace the process and don't be afraid of a contract that's of a sufficient detail to actually handle, current issues as well as future issues.
There is so much to unpack, and I wanted to go back to, you mentioned the NFTs, and there's some questions I had for Lillian, and I wanted to jump in with Thomas as well with some media rights and thinking about the future with respect to what happens when the deal changes hands, when the contract goes to another publisher, it goes to, is licensed by somebody else. But Stu, since you mentioned NFTs, I'm going to switch from my original order just a little bit and go over to Robyn, because NFTs, as you know, are a controversial topic. They're in some circles. They're also a very common topic in other circles where they're done every day as a matter of routine. And I know we've received a lot of questions here about that as well. So before I jump into what happens further down the line with contracts and a little bit about some of the more traditional deals with film and that sort of thing, since NFTs are on people's mind, I'm curious, since you actually have experience with this field, what your thoughts about how artists should be dealing with these kind of things when they come into the question, how artists should be dealing with some new technology and some of these technological issues that come into play when they're negotiating a contract.
Well, so we could talk about all types of art as far as NFTs go. So let's just keep this limited to comics, right? I think that'll probably be easiest for this discussion. And, you have a situation where you have previously submitted pages and cover art, physical paper, right? And now all of that's digital. And if you look at some of these contracts, it says that basically, the distributor is not going to return any digital art to you, whatnot. And up until NFTs, there wasn't a way to really assign value to that digital art that was submitted, right? Tell me this, Jeff, because you fielded the questions, how far back would you like for me to go as far as the NFTs? Would you like for me to explain how they work? I feel like this audience already knows that. Is that correct?
Let's
be correct.
Yeah, just to do maybe a 15-second explainer to sort of what an NFT is, and then let's talk about some of the contractual issues that have been arising.
All right, so NFTs, non-fungible tokens. The quickest way to explain it, let's use one original piece of art. You take that art, you mint it. When you do the minting, you're basically establishing the provenance that is held within the blockchain. I am using very general terms because I'm trying to give the capsule summary, right? And with that is the smart contract. And so the issue itself is not in minting or placing the NFT for sale. The issue that's been arising is who has those rights to sell that NFT. I think everybody knows that DC and Marvel released letters here recently about comic artists' rights as far as their originals, their one-ofs, fan art, which had been able to be sold, at conventions and whatnot. And of course, now since the pandemic and in view of the fact that everything's done digitally, now everybody's, looking to capitalize on that. Not to mention when you have people, selling for millions of dollars, everybody's like, well, wait a minute, I can get in on that. And so the issue we have now is, okay, well, what rights do we really have? Are these original one-ofs, or is this a copyright that still lies within the rights of the companies? And the other issue is, there's no clear answer. Some attorneys support this. I'm trying to be general here. Support the school of thought that, you know, okay, you've always had rights. So based on the behavior of the parties, you have the right to sell, do whatever you want to do with these one-ofs, these original pieces. I don't, looking at the evolution of contracts, I don't know that the answer is quite so black and white. And the other attorneys on this panel, please weigh in on what your thoughts are about this. I don't think the answer is quite so black and white because all of these contracts are drafted differently. And so like, here we are. So now, do the comic artists have rights to these one-offs, or are these rights, do they still lie in the distributors? I'll stop there and give the other panelists an opportunity to kind of weigh in on what their thoughts as far as the rights for the artists in these one-offs in the NFT market.
There was a question that you raised, Robyn, that was vital, and that was, what rights do we really have? Because that gets at the heart of a contract, because you're allocating who has the right to do what are the limits on the rights. So, you know, rates are a great place to start, but we're also allocating the rights. And I wanted to move to Thomas, because Thomas has experienced, when it comes to technology, there was a time when film was a new technology, radio exploitation was a new technology, even syndication was a new technology, which Stu was talking about with the cartoon area, the cartoon strip area. I'm wondering, Thomas, what your experience has been as somebody who's worked with technology and particularly worked with film and television, what you're seeing some of the best practices are, as well as some of the mistakes that have been made.
So let me sort of use what you were saying about NFTs and kind of springboard and answer what you're saying, Jeff. You know, when the 80s came around and video cassette technology, remember that, was first on people's horizons, there were a lot of cases from motion picture companies saying, hey, we have the rights to take this film and just put it right on a video cassette. And there was a lot of pushback because most of the contracts that had been done in the 30s and the 40s and the 50s and 60s really didn't contemplate what are called new uses and new media uses. And they just said, okay, the motion picture company has the right to take this film and maybe put it on television, maybe to put it in a movie theater. But it didn't have this catch-all phrase that we tend to use now, which suggests that if you are an acquiring party of rights, like a motion picture studio, most studios will put in some variation of a phrase which essentially says, hey, not only do we have the right to use it for a motion picture or a TV show, and then they'll list this laundry list of all the things we can do with it, but any use in media now known or hereafter devised, which is essentially this big bucket which says anything we come up with, you know, whether it's direct silicon chip implants into our brains, that's going to be captured by this. So sort of to go back to what Robyn was saying about the ownership of the rights in the NFTs. NFTs are clearly new uses. I don't think anybody in the 80s and the 90s were contemplating using NFTs. And I guess the place that I would look, because I agree with you, Robyn, I'm not so, I don't believe it's as clear cut as some people think it is, because you have to first take a look and say, okay, does the artist have the right to make derivative uses of, you know, of this character? Maybe they drew a couple of Marvel covers, but do they have the right to continue to make, you know, these sorts of images? And you also have to take a look and say, well, are NFTs, do they count as fine art in the same way that copyright law, which has some protections for, I guess the closest analogy I can figure is maybe photographic prints in 200 or less or fewer runs of an image. So we have some laws that kick in the copyright law when it comes to works of fine art for, you know, I'll use the term moral rights, although we don't quite have that structure here. Mm-hmm. But NFTs, I'm not so sure you can quite shoehorn them into that schema. So I think a lot of it will come down to facing a company like a publishing company or a studio and having to make the argument that no, this is a work of fine art. It's not a derivative work of your property. And I think we're going to see a lot of back and forth in that arena.
Mm-hmm. We're going on to, oh, sure, Lillian.
No, I just wanted to add to that also that, you know, there's a tradition in comics that the artist has the right to sell original art, even though the artist does not have the copyright in it. So,
Right.
Batman artists can sell their Batman art, just the original, not make copies. So much art now is done digitally that it would seem to me to be a good argument that instead of selling the digital art, you make an NFT out of it, and that is your single copy sale, the original art sale. So I would argue for that on behalf of artists.
Very interesting.
What I was saying about, I ran over to my client's contract and made sure that I had put in a specific call out to the reservation of original art. Because if there's a specific thing that says the parties thought about original art, single copy original art, and decided that that should lie with the artist, that is, as Lillian was saying, more evidence that it lies on the original art side. Because as Robyn said, if you're like, it's original art, and I'm going to make 247 copies of that, well, then it starts to look a little bit more like subsidiary rights.
Mm-hmm.
Yeah.
We have we're starting to get questions, and any of you in the audience, you have specific questions that you would like to ask any of our panelists, please feel free to jump in the Q&A and we'll start relating these. One question I had, and I want to, before we jump into some more about media rights and merchandising, there was a question about are NFTs covered by limited editions under VARA, the Visual Artists' Rights Act? Does anybody want to field that question? Because that's something where I'd have to do, because what's interesting is that, Robyn, did you want to jump in?
No, I was about to say that sounds like a question that I don't think any of us are prepared to answer.
Wait,
Very good question though.
What is that though? Like, what is that specifically, like, what does that address? The Visual Rights Act?
Anybody want to talk about that in brief, just sort of how that applies to, potentially how that might apply to comic art? There was maybe what we can do, is I can follow up on the Visual Artists' Rights Act in a post, because it's a very special area about the artist, and we'll talk about that. If any of you have been familiar with the 5 points scenario where people were doing street art on the side of a building and then the building was destroyed without the artist's permission, there's certain rights in certain contexts where artists have not to have their work destroyed or altered.
Okay, so that's interesting. I get that, or used in a commercial without paying the artist. Okay, so one thing that's interesting about NFTs that a lot of people maybe don't know is that interwoven into the programming or the I don't know, the technology of it is that every time it's sold, an artist gets some money.
Sometimes.
So okay, but that's a specific. Okay, yeah. See, Robyn more about that.
Yeah, so when this is what I was talking about. Like, we could probably all stay here for 4 hours talking about just the NFT contract side of it, right? Like, it's still right. There's still a contract, and it's still what rights do you negotiate in the sale of that NFT? Like, definitely, it's most advantageous for the artist to negotiate that every time it's sold, you get a royalty. But all of them are not necessarily structured that way.
Okay.
Mm-hmm. I want to throw that question gets to one of the big things that people are interested in for this panel, which is royalties. And if you've been following, this goes beyond NFTs to the more, I guess, traditional. It goes to TV, it goes to novelizations, it goes to just licensed product generally. And I'm wondering about the question of what happens to your work down the line. One of the themes of this panel is writing contracts that last. And so when you write a contract, suppose you're doing a licensed work, and some of you are familiar with this from the whole Disney must pay controversy. You're doing a licensed work, the publisher gets into a deal with you, you get some money. Or you do some merchandise, you get some money from the product. But then the publisher gets acquired, or the license reverts to the original licensor, or a number of other things happen. How do you protect yourself if you're an artist from those changes?
Good question.
So if I may, I actually have a slide on this. So
go right ahead.
So I'm going to grab the share screen, if I may. and we will go over, I know it's hard to get through a presentation without at least one PowerPoint slide. So here's our obligatory PowerPoint slide. All right, so what I have here is an assignment clause, because we're generally talking about assignments here. And perhaps let me set the scene a little bit before I dive into the language here and what this means. When you are creating a work and then you grant that work or sell that work to a studio or a publishing company, you're selling a bundle of rights or licensing or assigning a bundle of rights to that company. Then down the line, as Jeff said, that company may turn around and say, you know what, we're going to give all of these rights to somebody else, to another company. And in the case of the Disney Must Pay, we had Alan Dean Foster, who wrote a Star Wars novel. I think the first one, Splinter in the Mind's Eye. I remember reading that as a kid. Good book. I don't know all the details here, but let me stay on the 10,000 foot level anyway. His claim is when Disney acquired, I guess, the bundle of rights from the publishing company, and correct me if I'm wrong, Disney did not also assume the obligation to pay the royalties to Alan Dean Foster that he had been receiving from the publishing company. And so the question is, well, gosh, if we do a deal with somebody, how do we know that they don't turn around sometime later and sell the rights that I get money from as a writer to somebody else, and that person just washes their hands of all the obligations? And there's been a lot of back and forth online, and a lot of people weighing in saying, well, there's no way you can sell an obligation, or no way you can sell a right without the concurrent obligation to pay. And that's not quite true. There are ways that people can sell rights without the obligation to pay being assumed by the buyer, but the original company still stays on the hook. There are exceptions and then exceptions to the exceptions, but again, I'm going to stay on the 10,000 foot level. So assume you don't want to go into litigation and you just want to control for this, as Jeff said. How do you deal with this on the contract level going into it? How do you try and stop this from happening down the future, so you don't have to pay a litigator? Instead, you can just go to the contract and say, look, I'm owed the money. So what I have on screen here is a clause, a variant of a clause that came across my desk this week in a film deal that I'm doing. But I think it's nice, it's short, and it sort of gets us to that, to understanding the areas. Now, when you assign something to a company, you want to make sure that in addition to the rights that are being assigned, you actually deal with the issues of how to handle down the road the fact that somebody needs to remain liable for the obligations. So in this context, where a writer is conveying the rights to a screenplay to a producer, the producer must still remain liable for all the obligations, that is, all the payment obligations to the writer, unless the producer turns this over and sells the screenplay to a studio of some size, a major or mini major are the terms used in the film industry, and that studio in writing also assumes the producer's obligations. So one way of doing this is to write in the assignment clause, hey, okay, you can assign this, but I need somebody with a decent bank account to stay on the hook for payment, and somebody has to be backstopping this payment obligation. So to leave language like this out, and I would actually put more teeth in it. It's just this was the one that fit on the PowerPoint slide. But the thought being, yes, you can assign it to another company, but that company has to in writing promise that they will fulfill the obligations of paying you the royalties. And if they don't, you, the person who I assigned it to originally, still has to stay on the hook for payment. So that's
Lillian,
one way of dealing with it.
Yes.
Lillian, I'm curious. So you're looking at your same slide that Thomas has posted. As somebody who's worked with directly with the publisher, is this something that you see a lot of publishers that they would accept? Is there an alternative to this?
It's
I'm
so,
curious your perspective.
well, assignment clauses have not typically been a hot button issue, but lately there's intensive negotiation about them. And I was negotiating a deal on behalf of a publisher with the writer's agent, and the writer's agent, this was a deal breaker. The writer's agent would only agree to have the agreement assignable to a company that would succeed to all or substantially all of the publisher's assets. And that it came down to whether we would agree to that or not, and not do the deal. And we did agree. So it's a long way from Thomas's assignment clause, which is pretty good because it has all the protections there that a creator would need.
Mhm.
Did that answer you?
Yeah, definitely. Very. And do you see? That definitely answers. Any other thoughts from any of the other panelists?
At
It's definitely a hot issue.
Most publishers would say that the creator, writer, artist does not have any right to assign the agreement, except would have the right to assign the right to receive payment under the agreement, and the publisher would be able to assign to any third party. And traditionally that wasn't really argued about very much until lately. That publishers got away with that.
So, okay, so the Disney must pay, that's, I'm assuming kind of a blurb assigned to a moral outrage once people understood the nefarious nature of the contract that Disney that assumed, right? Is that what's going?
No.
No, that's not what happened with the dean, with the author guy, where he didn't. Is this not connected? Disney, the term Disney must pay is not connected to that author, or is that what it is, or?
It is, and that was the hashtag. So to answer the question, that's the hashtag, is the Disney must pay. And yeah, I agree to some degree. It's a color, it's an slightly inflammatory statement that's aimed at getting Disney to actually respond. And I'm not going to say that that I'm in Disney's camp on this one, because I think that artists should get paid. But yeah.
Okay, because it's interesting, because I think that what we're realizing is collectively is like that Disney has been, interestingly enough, on the receiving end of making decisions that are moral or not, like the Jack Kirby estate. Now, in no way did they need to do that legally, right? Like give money to the Jack Kirby family, even though Jack Kirby is entirely responsible for like at least half of what Marvel was, but was paid a pittance, while Stan Lee got all the money and all the accolades. Well, but Disney paid, and I think that there's something to be said about the morality of negotiating things, where it's like, you find out later, oh, this contract was bad because the artist felt like they had no understanding of contracts, no understanding of law. And it's interesting. Do you guys feel like that some of this, now that the internet kind of gets a hold of something and then can kind of hold companies accountable in some ways, do you like, what do you think about that? Do you feel like the morality of what is fair should be taken into account with negotiations and contracts, instead of the kind of exploitation battle that has traditionally gone on, not in artists' favor? Because artists have been, I mean, Simon and Schuster, I mean, everything, it's all exploitation. It's like the world benefits from art and creativity, but the artists themselves are continuously and relentlessly exploited to no end. Like, at what point do you just kind of do the right thing because it's fair and it's good, and that should reflect the world that we want to live in by being fair?
So let me play devil's advocate here, and let me start by covering my butt, because I used to be a graphic designer. I was a creative before I became a filmmaker. So I get you, man.
Okay.
But just to,
Well, I've got some exposure to pay you. I could,
but just to weigh in as devil's advocate a bit, you know, the terms, is it moral or not? That's a very sort of ambiguous place to be, because the counter argument is that, you know, if you had representation, if you read the agreement, you were good with these terms starting off. And
sure, I
you know, as
understand.
somebody like I'm sure most of the attorneys here who, depending upon the day or even the hour of the day, I'm either representing the creative or the company. So so there are two sides, and I don't mean to sort of say, hey man, it's like it could be either or, but I'm saying that depending upon the stake you have in the game, you know, that being said, I do tend to, unfortunately, I haven't fully been able to kill that artist soul in me, so I kind of do attach some moral weight at times where perhaps I shouldn't. So I do think that when an artist has been promised payment, there should be a follow through, and so I get that. But if the terms were pretty clear and everybody agreed that I have all the rights that I'm taking from you, and you're cool with that for whatever reason, and then down the road, a new use of those rights is invented. If the language in my contract where I got those rights from you said, you know, I get all the rights, then I'm not sure we're talking moral as much as we're talking, you know, legal and how to make certain legal arguments. I don't see that as much of a moral issue as perhaps some people do.
Right.
I think it's more amoral.
I think
than
that like alleviating yourself from having to worry about the morality of something allows you to be, you know, a good
it's
lawyer.
true. Yeah. No,
like
you're
if
absolutely
you don't
right.
have to worry about if somebody gets screwed or not, then you could be a good lawyer. And I'm not here to like judge or anything, but I'm just saying that if an attorney's job was mostly to just to like, I don't know, I mean, I know like this is me now this is me just challenging the entire structure, and that's ridiculous, but I'm just saying that like the negotiating terms of an artist in this particular world, in this context, is far less, even though the contributions of the artists are easily half of what the worth of the product is. So, but that never really happens. And artists are, generally speaking, never in any particular situation to be able to have the resources nor the money to examine and deal with a contract in a lot of ways.
Let me hop in here real quick.
Yes.
And here's why I want to hop in, because I do also patent licensing, right? And I also work with businesses on purchase agreements, you know, things of that nature. If we're talking about products, if we're talking about patents and whatnot. And what I see in those contracts, I see that those contracts are much more creative than some of my clients who are animators or in the movie industry. I noticed that you have things like this. Clearly, we won't get deep into it, but you have things like this. You have things like tiered royalty structures, milestone payments, ways to kind of take care of that. It basically, what it does is it distributes the risk evenly in the contract, saying like, okay, if this particular issue only sells 100,000 copies, then this is what we owe you, you know, as a royalty. If we get to 250,000 copies, then the royalty goes up by 0.5% or something like that. If we get to 5 million copies, then here we are. And this is another milestone, right? I find that patent agreements and general like venture capital agreements are structured in this way. But for whatever reason, like when you get to the strong arts or the fine arts, I don't find these contracts structured this way. What I've started doing is I have started to apply these principles to all the contracts, because I want to make sure that my clients are properly compensated going forward. So like there are ways to kind of contract around it if you get really creative, but you've not really seen that taking place, you know, up to this point, as far as, you know, copyrights and the trademark rights that kind of go hand in hand with that. You see it a lot on the patent side though.
That's
In my experience,
Lillian.
the publishers that I've worked with always have those structures. always have royalties that increase as sales go up. I mean, it's the standard. And one of my publisher clients shares revenues 50-50 with the creative team after recouping expenses. So, I mean, I think that Skinner, if you've been taken advantage of, that's awful. But the publishers that I've worked with want to do a good deal with the artist and the writer because they want to continue working with these people and they want to have a good reputation. So
Yes.
I guess it depends on, from publisher to publisher, it can vary. And certainly the contracts vary, but I've always worked with tiered structures.
Yeah.
I have a question. Oh, Stu, please jump in.
Yeah, I want to jump back to your previous question, I think to Thomas, which is, would publishers and buyers accept that more complex assignment language? And I really only represent artists, and I see everything from brand new people who are working out of a coffee shop to incredibly successful people. And what I can say is one of the other great realizations I had in my career is that pretty much every negotiation, people have an appetite to spend 3 to 5% of deal value hashing out the contract. I mean, people, if a deal is worth $1,000, nobody wants to think about the commas and have more than a 2-pager. If a deal is worth $2 million, then, we're talking about a 50-page contract and everybody's going to fight over every word. So I think that if you have a long-term contract where there's a lot of money at stake, you probably can delve into some of these assignment details to close off side case risks. But if you're doing a small deal, you probably won't be able to. And then, so I just wanted to answer that question. Because, I mean, it really is no such thing as a one-size-fits-all. People get really nervous if they're spending more than about 5% of deal value. And then if they're just throwing out a template, they'll throw out anything because there's no downside until the other side starts pushing back and the transaction costs get outside of what everyone's comfortable with.
Yeah,
One of the things, Thomas, please jump in.
Sure. Just very quickly to button out on that. Comic books right now are big hot properties, have been for a few years. Hollywood has recognized them as a great feeder system. And Hollywood's a good model to look at because there are a lot of standard terms like the assignment clause that I put up on the board a little while ago is taken from a Hollywood generated deal. So what I'm finding in my practice is people are turning to these Hollywood models, and Robyn, sort of to your point with the assigning risk over different points. We call that in a Hollywood screenwriting deal that might be called a step deal, where a writer's paid for the treatment, and then a writer's paid for draft 1, and then the revision, and you get paid commensurately with your delivery steps. So a lot of the mechanisms that I'm seeing in my practice, and maybe it's because I do a lot of the comic and film both, but I'm seeing mechanisms that we already have pretty well established in film and TV starting to be ported over to comic books, as opposed to looking at the traditional publishers and having that drive the train. So I'm seeing more from the film side influencing how we do these transactions on the comic side.
Well, I want to build on something that Skinner was saying about how the artist doesn't know, and we're talking about building in things from film. And I know, Jordan, you emailed me, not Jordan, Stu, you emailed me a very interesting contract that you saw earlier this week that had an issue that I thought should be flagged. A lawyer will read a contract with a certain eye. Like, for example, the possibility of splitting rights and obligations. To a lawyer, that's very, very familiar. It's been around for hundreds of years. To an artist, it's very surprising. What sort of traps, whether the new style contracts or the traditional contracts, what sort of surprises are out there that creators in particular should be wary of in a contract, that they should be thinking about wanting to avoid, or understanding that things could happen that they're not expecting? And definitely from any of you, please feel free to jump in.
Well, the thing that has really defined the syndication industry over the last 40 years is what's the duration of the contract. It used to be that the syndicates, the comic strip syndicates, would be the copyright holder. And so that's basically a permanent contract. And then the leverage switched back. And so the artists would typically hold the copyright. And so then the actual contract duration became a linchpin, whether it was 10, 15, 20 years, what have you. And then when the syndicates realized they'd given up too much, the pushback became, okay, fine, you can have the copyright, and you retain that, and we'll have, you know, a certain number of years as to the term. But to your question about what's the risk, what you have to look for is what is the post-term situation. Do the rights fully revert back to you? Are you, you know, in sports analogy, are you a free agent? Are you a restricted free agent where they can negotiate?
Right.
Are you, or are you just perpetually actually tied to them? I mean, like one of the provisions I see all the time is, yeah, sure, you can leave and you can do whatever you want. Oh, but we still get our half of the money.
Mm-hmm. Yeah.
You're really actually free. Like if you leave, then they don't have to do anything. They still get their half. So that's actually a burden if you leave. So when you look at contract term, and you have to look at the term and the grant of rights and the post-term provisions, and all of those as a basket will tell you what's your actual obligation over time. That's the big risk, is that you think it's a 5-year contract because it says 5 years, but it's not really, because they have their hooks into you for a lot longer. And it's not necessarily unfair if they create a lot of value for them to have a longer term interest, but be aware that, you know, whether you own the copyright and whether or not the contract technically ends on a certain date is not the end of the analysis.
You know, I just, we have 2 minutes left, and I'd love to continue talking on that question, but I've just got a question in from Steve Comley, and I wanted to run that by you maybe as something to close. And then if anybody can stay a few minutes extra, that would be wonderful. If not, I certainly understand. We usually get presented with the publisher's, licensors, boilerplate terms. Is there a recommended or established set of rights we should be starting with, including the assignment issues and new NFT concerns, a simplified primer? And do we need to draw it as a comic so we cartoonists can understand it?
It's funny because there's a great comic out, and Jeff, maybe you remember who it's from, but there's an illustrated copyright guide comic book that some law school did that was really really wonderful. You know, cut me off if I'm about to say something I'm not supposed to, but I was going to just talk about a book that I wrote that deals with a lot of these. Yeah, so I wrote a book called The Pocket Lawyer for Comic Book Creators, available wherever fine legal books are sold. And I wrote it very much with comic book creators and artists in mind. So I try to dial back on the legalese. I have to say, I don't deal with NFTs in it, but it gives you sort of a primer on other contract and copyright issues that you may want to be aware of. And also come see our lectures at New York Comic Con, which Lillian and Jeff and hopefully maybe some of you other panelists may be on as we continue on into a bright, hopefully COVID-less future.
Other thoughts on whether there should be any additional templates? Or let me just close since it's 2 o'clock. What parting thought would you give to our attendees in terms of a contract right or wrong? Just one sentence thing to keep in mind as they're going into their own contracts. Just one from each of you.
All right. Don't be afraid to use a lawyer. If the other side says, I don't want lawyers involved, that is a red flag. Run away, don't walk. People take you more seriously if you treat it as a business, and that means get a lawyer involved.
Don't agree to a right of first and last negotiation for additional rights. A right of first negotiation is appropriate and fair. A right of last negotiation really will not let you negotiate with a third party, because the third party will know that you're just trying to negotiate a better deal and then go back to your original publisher who has a matching right. So that's, I would not agree to that.
Fascinating.
I'm going to steal Skinner's. Don't be afraid of the process. The process is your friend, just as at the end of the day, if you get a good contract, the contract's your friend.
And I too will steal from Skinner a little bit. I say know your value and negotiate from that perspective. In this particular internet age where unfortunately your social media presence and whoever you are and how many followers, like know how much that asset is worth and leverage it. That's what I'd say.
Yeah, I guess I'll just say, don't be afraid to say no if it doesn't feel right, if it doesn't feel fair. Like, you have to pay attention to your gut, you know. Plus, you know, there's so much avenues of independence today. You know, you could do your own thing. It's just a little bit of extra work. You know, you can make, I think that's one thing I didn't get to cover, and I'll make it fast, but you sign up with like a big company and they sell like 100,000 copies of something. You could make just that the same amount of money selling like 20,000 or 30,000 of your own online, and then you retain the ownership of the whole thing, and then you're building an independent empire, you know what I mean? And then in the future you can leverage that against whoever is trying to approach you about stuff, you know. But anyways, that's all.
Excellent, excellent. I'll throw in one of my own, which is don't necessarily rely on unspoken understandings. I've run into a number of deals where people come to me to look at contracts and they say, oh, people said, don't worry about the language because they were going to let me do X or Y. And then as soon as the deal was signed, then they lost all rights to their property, or they didn't get to sell art they thought they had the right to sell. Get it in writing for a contract is very important. I want to thank all of our guests. I know we've run a little over time, but thank you so much. You were all amazing, and I feel like I could continue asking you questions, and I'd love to hear your thoughts for another couple hours, but I know you're all incredibly busy. Thank you for joining us and sharing your time, and thanks also to the attendees. We do have a few more questions, but we'll answer those probably. I think what we'll do is I'll just answer those online through our Twitter feed because I don't want to keep anybody here unnecessarily longer. But thank you all. Karen, do you have any parting thoughts about what's next?
I do. I just want to thank everyone who joined us today, and this will be posted. So if you know someone else who will benefit, it'll be on our website shortly and shareable. Thank you to all of our panelists. And we do just want to put a little pencil in on your calendars. Our next event is June 24th, and it's Recoding Censorship. So we're talking about how censorship has evolved, changed, what it looks like now. And, you know, a lot of our conversations today were sort of like, how do you predict what things can look like going forward? How do you protect yourself, prepare yourself, defend yourself, participate actively? So we'd love to see folks there for that event. On behalf of the team, anything else here from our CBLDF folks before we sign off?
Thank you guys so much.
Big gush for a sec. Yeah. Oh my gosh.
Thank you, everyone.
This has been incredible. You're all incredible. Your expertise is just so appreciated, and this has been amazing to listen to. So thank you so much.
Thank you. And the questions we didn't get to, as Jeff mentioned, we will follow up so you can get some of those resources answered as best we're able. We'll link to Thomas's book as well. And if anyone here has resources they want us to share and compile, we will be happy to do that.
Then we'll throw this recording up as well so you can watch it again.
Yes.
All right. Thank you all. Thank you all so much, and have a wonderful day.